Welcome into Mock Trial Masterclass, your guide to controlling the courtroom. I'm Luke, and I want you to be a mock trial master. Let's talk about how you can make that happen. A while back, I made a video breaking down some of my biggest mock trial pet peeves. You guys seem to really like it, so today we're going to go through another list of my least favorite things that I over and over again see teams and competitors doing in mock trial. And I'm going to give you the same preface I gave you last time. If something on this list is something that you do, don't get upset, don't get offended. I still like you, I'm still glad you're here. But cut it out. Quit doing it, and I'm going to explain for each of these things why I don't like it, and more importantly, why it's just not overall, in my opinion anyway, effective in mock trial. Let's hop in. Pet peeve number one, bad relevance objections. Here's the thing about relevance. It is the easiest one of the rules of evidence to understand because it's a word that we use in our everyday language. All right, you have probably been in a conversation with someone maybe talking about politics or sports, and they bring something up and you say, well, I just don't think that's relevant. I don't really think that matters. Right? We intrinsically understand what that word relevance means, and so for newer mock trial competitors, it's a very easy rule to start to understand. Ipso facto, it becomes a very easy objection to make as a mock trial competitor. But because of that, I often see competitors falling into the trap of just lazy relevance objections. It becomes, my coach told me I need to object sometimes to throw the other team off. I heard this thing, an objection relevance. When that's the way that relevance objections go down, they become such a time waster. The best framework I've heard for deciding whether to make a relevance objection comes from the great book, Winning Objections, where the authors talk about passing the eye roll test. If a piece of evidence or if a question doesn't make you roll your eyes as an attorney, then it's probably not worth a relevance objection. Relevance is a really low bar, and it's a hard objection to win a lot of times because of that. Evidence just has to have, as the rule says, any tendency to make a fact of consequence more or less likely. And it's just really easy to do that, making it hard to win relevance objections. So if you're sitting there and a question doesn't make you roll your eyes, I would not object to relevance. If it does and you're sitting there going, oh, why are they asking this? That's your signal to stand up and make a relevance objections. But this makes my pet peeve list just because these needless, useless relevance objections take up time. And it's not that I've got a plane to catch or anything, but if we're just wasting time in a mock trial round, let's get things moving and not do that quite so much. Pet peeve number two is in the course of an objection exchange when an attorney says, may I proffer? Now, proffer is just shorthand, as I understand it, for offer of proof, right? Offer of proof, proffer, right? I have no problem with the concept of proffering or making an offer of proof. I just think it's a stiff, weird phrase to say. I don't know that I've ever actually heard a coach teach their team to say, may I proffer? Now, if your coach does, correct me in the comments below, let me know. But my hunch is that this comes from competitors hearing other competitors at competitions say this, and then they adopt it into their own performance. And if you don't even know what I'm talking about, here's what it sounds like. So, other side stands up and says, objection hearsay. And I say, may I respond, Your Honor? And they say, yes. And I say, Your Honor, if I may proffer, and then I give my objection argument. I just think a much better way to do it is to I just think a much better way to go about it is to use more casual language. Your Honor, if I may explain. Your Honor, if I may use an example, right? If I may make an offer of proof, right? Anything other than that phrase, proffer. There's nothing necessarily wrong with it. I just think it sounds stiff and makes you sound more like lawyer man or lawyer woman than a real human being. Yes, you're addressing the judge and not a jury, and that's a little bit different. But just let those shoulders down a little bit and don't use proffer. See if you can come up with something else to say. All right, pet peeve number three is the phrase, ladies and gentlemen of the jury. And I know this is the one that the most of you watching are going to go, I say that all the time. What's wrong with that? There's really nothing wrong with that, but let me explain why I find it a problem. Most of the time in mock trial, you're going to have a scoring panel of 2 to 3 judges. Most college rounds tend to have 2. Most high school rounds tend to have 3. And so if we've got a scoring panel of 2 judges, and we've got 1 dude, and we've got 1 woman, and we walk up to them and we say, ladies and gentlemen of the jury. Well, there's one lady and one gentleman. What if we got two dudes and we walk up and we say, ladies and gentlemen of the jury? Where are the ladies, right? That's odd. Same if it was the other way around. If it's two women and we say, ladies and gentlemen of the jury, where are the gentlemen? Why are we saying gentlemen? It's weird. And again, even if it's just, 2 and 1, if we've got two ladies and one dude over there and we say, ladies and gentlemen of the jury, it's only one gentleman. We don't have gentlemen in that situation, right? And I've heard attorneys do things like, if it's two women, ladies of the jury, or if it's two men, gentlemen of the jury. And I just think that's really awkward most of the time. My preference is to just substitute that phrase at all points for members of the jury. I actually like that phrase. If you caught me in a mock trial round, you would hear me saying, members of the jury. I have nothing problem with, addressing the jury in that way. It's just the ladies and gentlemen thing doesn't really work if you only got 2 or 3 people sitting there, which is what you run into most of the time in mock trial. Members of the jury is much more universal, it's much safer, and it's going to prevent you from making a mistake in terms of misgendering the members of your jury. Pet peeve number 4 is when attorneys on cross-examination use the phrase, well, you say in your affidavit, or you said in your affidavit. There's usually 2 ways that this happens over the course of a cross. The first is during what should be an impeachment. I ask the witness, the dress was red, right? And the witness says, no, the dress was blue. And then I say, but in your affidavit, you say the dress was red. That is a problem because you're not going through the proper procedure for an impeachment. If you don't know the proper procedure for an impeachment, I'll leave the link to that video in the description below. But the Cliff Notes version for right now is that when you're making an impeachment, you need to follow 3 important steps. You need to get the witness to confirm their answer. You need to credit the affidavit or witness statement by talking about what it is. And then you need to get the witness to contradict the answer they gave a second ago by you as the attorney reading from their witness statement. It's very important to follow all 3 of those steps because I firmly believe that impeachments more than anything are rooted in that process. And if we just throw out, well, in your affidavit you said, we're missing a lot of steps that are just super, super important. So don't do that. Don't just say, well, in your statement, go through the proper steps of an impeachment. The other time I see this popping up in cross is what I would just call the useless bringing up of the affidavit. Because here's the thing, in mock trial, everything that we are crossing or directing, for that matter, a witness on, comes from their affidavit. So theoretically, we could start every question with, now in your affidavit, you said you didn't see the killer. And in your affidavit, you said it was 5:30 when whatever happened. And in your affidavit, we don't need that. If we don't need it in every question, we don't need it in any question. And here's the thing as well. Technically, if we're saying, well, in your affidavit you said, and in your affidavit you said, if you want to get really technical and philosophical about it, it's kind of hearsay, is it not? We're using this out-of-court statement, the witness statement, the affidavit, and bringing it into court to try to prove that it's true, which is the very definition of hearsay. So moral of the story, you don't need that phrase if that's the reason you're using it. Just ask the question. You don't have to say, and in your affidavit you said the sky was blue. Just say, you believe the sky was blue, or the sky was blue when you saw it. Cut the introductory phrase, not necessary. Before we get into my 5th and final mock trial pet peeve of this video, I want to remind you guys that I offer coaching to mock trial teams and individual competitors. I work with teams all over the country at the college, high school, and even middle school levels, helping them take their performances to the next level. I love teaching and giving workshops on mock trial ideas and concepts. I love brainstorming with teams as they look to develop their content, and I love sitting back and watching teams deliver their content and providing live feedback as a part of that. If this is something you're interested in, you can get the ball rolling on setting up a time by clicking the link in the description on YouTube or in the show notes on podcast platforms. All right, 5th and final mock trial pet peeve of this video is attorneys giving commentary during direct or cross-examination. Of the pet peeves we've gone over on this list, this is the one that will often give me the absolute biggest eye roll, and it's because it's just so weird when it happens. Here's what I'm talking about. Please tell us your name. My name is Mackenzie Michaels. What do you do for a living, Ms. Michaels? Well, I'm a sheriff with the Empyrean Police Department. Interesting. Well, what do you do as a part of that job? Well, I investigate crimes all day long. Interesting, right? Do you see what I'm doing? This like commentary of interesting. And it gets even worse on cross-examination. Now, you're a sheriff for the Imperion Police Department, right? And that means that you work with criminals all day long. Okay, and right, you just don't need those little bits of commentary. Some people would even call it editorializing, right? Most judges won't even let you get away with that. If I was competing against you, I would stand up and I would say, objection, Your Honor, opposing counsel is commentating the direct examination, or opposing counsel is commentating the cross-examination. And virtually every judge would say, yes, Mr. Worsham, you're right. Opposing counsel, quit that. So quit that. There's no need for it. I think a lot of times it's just like a nervous tick of like, there's this silence and I don't know what to say. And I go, very well. Or, I heard one time an attorney kept saying, noted, after every cross question. And then this, well, that's not exactly true, noted. And then this, yes, noted. It's just not necessary. So cut that stuff out. If you're feeling the temptation to fill the space, just resist with everything you have. Pauses are a great and effective thing. Don't fear the silence. It's A-okay. But those are my 5 mock trial pet peeves, and I'm curious, do you have any that you would add to this list? Leave a comment below letting me know what yours are, and maybe I'll cover them in another pet peeve breakdown in the future. Overall, just don't do this stuff. You might disagree with me on 1 or 2 of them, but for the most part, this stuff is just ineffective and should be avoided.